going to look at Amber Heard's argument about improper jury service. A lot of lawyers have already gone over this, and I've addressed it in a previous video that one of the things Ms. Heard's attorneys had asked for was an investigation into the identity and service of juror number 15. So let's look at the mysterious case of juror 15. We'll take a closer look at this argument because at the end of last week, Ms. Heard's attorneys filed a supplemental memorandum based on additional discovered facts relating to this argument over juror 15. The consensus was her argument was extremely weak, especially based on the clear statutory language in Virginia. Now she's filed a supplemental motion. What is going to be in it? What kind of shocking new evidence is disclosed in this motion that Ms. Heard has filed, this supplemental brief that she's filed? The argument is that the juror identity was not validated as the court was required to do, so the wrong person ended up serving on the jury. What's the evidence for that? Is there a picture of this person that they found later on wearing a shirt saying Depp's #1 fan? A YouTube clip of this person saying, I can't believe I scammed my way onto this court and I'm going to write a book, make a lot of money. Affidavit from another juror saying, hey, this isn't who he said he was. The only evidence presented in the original motion by Ms. Heard's attorneys and in this supplemental new facts motion that say that this was the wrong person is Ms. Heard's attorney says this person was obviously not 77, which was the age of the juror given on the jury panel information, and which also was available to Ms. Heard's attorneys before the trial started, during the trial, before any alternate jurors were dismissed, during deliberations immediately after the verdict. But now suddenly it's an issue. You can see this is going to be a problem. For this kind of due process on its face argument, you would like to be able to show the court, here is some evidence that I've got, some clear evidence that this was not the person who was supposed to be sworn in, that this was someone else, and here's evidence that this was done in a way and that affected my due process. In other words, this juror was prejudiced. So there was somebody trying to get on the juror, maybe to be famous or whatever. They had animus towards my client or a prior background that would cause them to be unfair. Those things don't exist in this case. Instead, the only evidence that it was not the right person is the assertion that it was obviously someone younger. Okay, well, first of all, you knew that during the whole trial. Secondly, is that really proof that it was the wrong person? How do we even know it's not the right person? That's just her assertion that, as I remember watching this guy, he wasn't really that old. So throw this whole case out. It doesn't sound very compelling that way, does it? Also absent from these arguments is any impact that this juror made. Again, there's no Facebook post saying, I can't believe that I voted against Amber Heard. That was awesome. I hate women. I love Johnny Depp. There's nothing. There's no statements referenced that this juror did anything improper in the course of the trial. And you will know, of course, that the jury was unanimous in its verdict. Not just this one person they have an issue with, but the entire jury was unanimous. Secondly, the judge sustained the verdict, and she could have thrown it out at any point, including after the jury came back. So everybody reached the same conclusion, and they have an issue with this person who they say is the wrong person because now they've decided the person looked too young, and they want the court to reopen matters and look into this. On one hand, it's important that you have an impartial jury. You don't want somebody sitting on a jury who's obviously biased against one party, who will not fairly deliberate. That's wrong. Okay, so everybody supports that. If that process is frustrated by a juror who lies during attorney or the judge's questioning about their beliefs, other material things, a fraud on the court, in other words, that's obviously important too. You don't want somebody who's behaving in a dishonest way serving on a jury, not giving both parties a fair shake. So that's one side of it, and that's very important. The second side of it is the justice system needs to move on with cases, and when you have a unanimous verdict like this, it wasn't just the one person, okay? So what are the odds that that person was the only reason these people voted this way? So you have to look at the competing concerns, because you do not want to create a situation where you incentivize attorneys during the course of a trial to do rampant investigation of every aspect of jurors' lives so that they can find any kind of inconsistency or any alleged problem or whatever. Hang on to that knowledge through the course of the trial. Wait until a verdict is rendered. And then if they don't like the verdict, then they pop up and say, hey, this juror made a troubling Facebook post 3 years ago or 2 years ago or even last week. You don't want that. So there is a requirement, essentially, usually, for the attorneys to, if they know about this, they need to bring it up. And we'll look at that in the Virginia law in just a moment. that you can't set it in your back pocket and just see how it all works out, because then you have this whole trial, and at the end of it, if you don't get what you want, then you're going to have a new trial about it. 1, 2, every single juror's prior behavior, what they said, how they looked at me in court, etc. So there is a strong bias unless there is a fraud on the court and you can show some impact that caused the trial to be unfair to you. You pretty much need to do those two things. If you can't do those two things, they're going to let the jury verdict stand. So that's an uphill battle, even conceptually, and it gets worse if you look at Virginia statutory law and case law. Ms. Hurd's argument, it's a big mountain to climb. I don't even think she has her boots on. Let's take a look. In Virginia statute 8.01353, if you look down in section A toward the bottom, any error in the information shown on such copy of the jury panel shall not be grounds for a mistrial or assignable as error on appeal, and the parties in the case shall be responsible for verifying the accuracy of such information. Not the court, the parties. So in this case, the form said that the person was 77. Ms. Hurd's attorneys now say, hey, that was obvious the whole time. That was wrong. Like, this dude looks way younger than that. There's no way he's 77. Okay, why didn't you bring that up then? She kind of makes an argument in her supplemental information. We had a pre-approved list of voir dire questions, so I really couldn't bring it up. That's a non-starter. Maybe you didn't ask it at the moment to the jury if it wasn't on the list. You absolutely could, of course, bring that up to the judge at any time during the trial and say, you know what, I'm looking at something here, Judge. This can't be right. This says 77. This person looks like they're 20. We got to check this out and make sure that's a discrepancy on the form or what's happening here. You could bring that up at any point. Now, granted, if the trial's in progress, you may already be shot down. The main point is you don't really want to wait until after the verdict comes back and the judge has said it's time to move on with life and then start talking about, that person looked very youthful for their age. I'm not sure if they're moisturizing or if it's a fraud on the court. Who can really say? We better open this back up. Again, the parties are responsible for verifying the accuracy of the information. Subsection B below that says, no judgment shall be arrested or reversed for the failure of the record to show that there was service upon a juror of notice to appear in court, unless made a ground of exception in the trial before the jury is sworn. No judgment reversed for the failure to show there was service upon a juror. Let's move on to the next statute. 801.352A. Prior to the jury being sworn, you can make objections without leave of court for irregularity on the list, irregularities in the drawing, the summoning, returning, or impaneling of jurors. You can make those objections. That did not happen here, even though allegedly this was obviously someone too young to match the information given. They didn't make the objection at that time. Subsection B, unless the objection to irregularity or disability of the juror is made in subsection A, and it needs to be intentional or probably cause injustice to the accused in the civil case, then it's not going to be cause for summoning a new panel or juror or for setting aside a verdict. So you have to meet section A, which, look at the first words, prior to the jury being sworn, and then in section B, you need to show that there's probably a cause of injustice to the accused in the civil case, or at least that it was intentional. And those things were not alleged in the brief that Ms. Hurd's attorney filed or in the supplemental memorandum. There's no evidence that there was a juror doing anything intentional, okay? There's just her assertion that they look too young. That's it. So this doesn't seem persuasive. Before we move on to the case law, let's do a little midpoint quiz. The statutes I've talked about, do they seem to say, hey, anytime you feel like it, whenever you feel like it, based on whatever you feel like, if you had a problem with one of the jurors, just let me know, okay? Even after the verdict's in, it doesn't really matter. We'll throw months of work out. It's not a problem. We'll just select new jurors that you also may have a problem with later, and we'll just do this trial again, and we'll just keep doing it. I mean, we really don't have anything else to do. Let's just keep doing the same trial over and over again. Or do they seem to suggest if there's going to be a problem with a juror, it's on you to figure it out, and it's on you to make your objection in a timely fashion? I'm going with B. But if there's a question in your mind, let's take a look at the Virginia case law and see what the courts have done about it when it's been brought up. Looking at the cases, I'll start first with one cited by Ms. Hurd's attorneys. And it notes in her favor the right to a jury trial is one of the cornerstones of our legal system. The process of securing a fair and impartial jury includes the ability of the parties to investigate potential jurors for information which may disqualify a juror or otherwise impact the jury selection process. Nice. I like the language. You know what, though, in that case, even though the judge threw new jurors at the defense counsel on very short notice, they let the jury stand anyway. Let's close that window. Looking at the next case, which Law and Lumber had found doing a Lexis search, it was Virginia court. A juror had responded no to the question on the jury questionnaire, have you ever been convicted of a felony? This person had been convicted of a felony, which can be a disability to being a juror, but had responded no. So, counsel filed a written motion to vacate the judgment, saying I was not provided my right to 12 qualified jurors. The court said, we affirm this conviction because there is no evidence that the irregularity would probably cause injustice. So in other words, if you can't show us what the injustice was, what's wrong with this, yes, this juror did something wrong, but how did that affect your case? You didn't show that at all. We're letting the verdict stand. Again, there's nothing in this case, in the Heard case, that says that Juror 15 has made any statements or engaged in any activity to show some kind of wrongful bias or impact on the case. Another case from Law and Lumber, Search, says the defendant complains the trial court's refusal to set aside the verdict and grant a new trial. The ground on which the new trial was sought, one of the jurors and the plaintiff's counsel had stood mute when the trial court asked, do you have any close relations with either the parties or any of the attorneys in this case? The plaintiff's counsel was representing a juror in this case in another court, and neither one of them said anything. Okay, that sounds pretty bad. In fact, you could say that's got to relate to some bias, right? Maybe so, but it didn't meet the first element. The point was raised on a motion to set aside the verdict. The question is controlled by Code 8202, saying no irregularity, etc., can be sufficient to set aside a verdict. We already looked at that, or the modern version of it. No objection was made before the jury was sworn. It was incumbent upon the defendant to show that he was injured by the alleged irregularity in impaneling the jury. It didn't show that, even though it was the same counsel. So here's a case where the person was represented by the plaintiff's attorney. That got found out later, or at least alleged later, and they still let the verdict stand. It doesn't look too good on the case law side either. So let's look at the three strikes. First, have you actually shown evidence that the thing you say happened? In other words, the wrong person showed up and participated in the jury. What's the evidence? Just your assertion that now, after the trial's over, you're pretty sure that they look too young to be the actual person. I don't know. How close do people have to look in age before that becomes suddenly evidence to investigate a jury? To me, that's strike one. You should have more than that. You should have something, a picture of the person proving it's the wrong person. You got to come up with something. Strike one. Strike two, did you timely make your objection? Under Virginia law, it doesn't look like it. All of the law points toward you need to get that objection in early. You had the information. It's not like they told you after the trial was over, hey, this person's supposed to be 77. You were told that before the jury was impaneled. Why didn't you make the objection timely? Strike two. Strike three, what's the actual evidence that this is prejudicial to your case? Again, did he have Depp #1 fan shirt on Facebook last week? Was Depp flying him over for a concert? Book deal? Interview where he said he hates Amber Heard and hated her before the trial started? Is there any evidence of prejudice in this case? Haven't seen any of it. That's three strikes. I think the judge is going to throw this one out. It's great for headlines and clicks and caused me to make this video, but in court, I do not see this as a winner. It still looks like a loser. Thanks.